want to make a couple comments and then look towards kind of follow-up questions about what we do with this time that we have before us today. I also want to call out a couple things. One is the fact that, there's been the comment about NIMBYs, and there's been another comment about, it's only a few houses or other things. And I think I want to state that, in my opinion, as I'm gonna poach a quote that somebody else said in reference to this action or this business structure is that if it looks like a duck, if it walks like a duck, if it quacks like a duck, it is a duck. This is a commercial use in an area designated as land-intensive agriculture that does not allow commercial use. I would take that beyond the land-intensive agricultural designation, and I would go into other areas as saying, does this qualify? Is it a timeshare? Is it not a timeshare? Do we have multi-tenant occupancy allowances in those areas, or do we not? And, the reality is that if you do anything commercial in an area designated as land-intensive agriculture, you have to go through a lengthy use permit process. If you want to grow cannabis, you got to go through a lengthy use permit process. If you want to do a winery that even has tasting by appointment only, or just a production facility, you have to do that. And we have also said by decree of this board and according to our general plan is that we do not allow vacation rental by owners in land-intensive agriculture. The only thing we allow is farm stays, which are very restrictive, and the reason they're not flourishing is because it does require a heightened degree of stewardship. You have to be an owner on property. You have to be more of an agriturismo mode, like we see in places like Italy and others. And so when you don't just have a fractional ownership that is an LLC, but you have a company that tends to that and sends services to those areas, furnishes the place, brings people in and out, cleans before and after. You know what that sounds like to me? It sounds like a hospitality operation. And so I am interested in addressing this from a few different places. One is our current code and the enforcement potential. And then the second thing is what kind of legislation we have to look at in terms of how this fits or what loophole is being taken advantage of that we need to close. So that's going to dictate kind of a variety of my comments, and I'm interested in hearing from my colleagues a little bit before I start to propose things. But I also want to honor the stories of Jan and Yael and a couple others who called in and acknowledge that, they did call our office in January, and it already started a couple months before. We met with them. There was a lot of frustration that this area that has been protected for agriculture primacy, and then obviously there's rural ranchettes that live out there as well, that this area was a threat to the direct neighbors, but also to the wider area. They're used to seeing small sparks turn into large fires in terms of issues that impact their area. They're very used to, as Lou Preston said, issues where even though we have a right to farm ordinance that sanctifies and says that you can do ag practice in those areas, they're very used to the fact that people complain about the smoke, and they complain about night harvest, and they complain about other things when the primacy is agriculture, and it is not commercial activity and hospitality. And I also want to honor the fact that they've been waiting for us to talk about this publicly since January. And there is a threat of litigation. It was denoted, it was talked about, but I want to give voice to the fact that us having continued conversations about the risk of taking action does not obviate our responsibility to protect against what we see as our code and what we see as contrary to land use in specific areas. So, everybody's worried about being sued by a big company that raises a lot of money, right? I challenge myself and us to look at what are the zoning actions now that we can take, what is our reliance upon our own code that we need to depend upon for that, and then secondly is what legislative actions do we need to make and who do we need to team up with to do that. I know that Hillsburg and Sonoma specifically, these are tourist havens. They're very interested in collaborating with us. I do know, even though staff didn't mention a lot of it, that there is a lot of different counties and cities that are trying to figure out how to move on this. and how to move in a way that they don't get hammered with lawsuits and lumped into situations where they owe millions of dollars in lawyer fees because they are trying to make sure that their code actually enforces what it needs to and what they see it as, but that there's a legal loophole that needs to be identified. I'm also interested in what actions we take in our state portfolio with requests to the state legislature to take care of this for all counties and all cities, not just those of us who are willing to step in and be sued to do what we think is right. That's my statement for me, not for anybody else up here. So after I hear from my colleagues, I think you can tell I'm interested in direction to staff. I'm interested in us taking action in front of us, and then future action legislatively, and then us being a part of a coalition that addresses this honorably. Final thing I'll say is I got nothing against any company. Companies try to figure out what makes the best opportunity for money. I would love to only have to invest 12% into a luxury property that my wife and I could visit. But the reality is that I see this very directly as contrary to what our code states and what our practices on the ground with respect to land-intensive agriculture specifically and some of our other zoning. So thank you.